Everyone, so I am seeing you all after a very long time. Hopefully the next time it wouldn't be such a long time. So anyway, I hope your accounts exams went really well, better than you had expected, and you are definitely and totally prepared for your law paper also. So as you can see behind me, the topic that I am going to do today is a very short, crisp recap on the chapter Indian Contract Act. You already know this is one of the major chunk of the portions from the other laws, and you will definitely get a compulsory question as well as obviously choice questions also from this chapter. So hopefully in this whatever duration of the lecture that we have, in this recap we are able to do everything that is there in this Contract Act. So let's just start with it. So moving on to the first one, obviously we know for CA Inter you don't have the entire Contract Act, you only have the special acts, special contracts, that is contract of indemnity, contract of guarantee, contract of bailment, contract of pledge and contract of agency. That's all that you have in your syllabus here. So we are going to start with contract of indemnity first. In fact, in all the 5 types of contracts, this is the smallest one. There is actually nothing much, just 2 lines to actually explain it. So when I say indemnity, the word indemnity means to make good, right? The word indemnity means to make good or to repay. So applying that whole concept here, it gives us the same meaning. So when I say contract of indemnity, it means to make good. So one party is promising the other party. One party is promising the other party that if you suffer any loss, what loss? Due to me or due to any other third party, I will make good that loss. That is, I will, to put it in simple terms, I will compensate you for that loss, right? I repeat again, what is a contract of indemnity? One party gives an assurance to another party that if you suffer any loss, now which loss am I talking about? Loss due to me or any other third party. If due to me or any other third party you suffer any loss, I will compensate you for that loss. This is a contract of indemnity, right? This is a contract of indemnity. So the person who is making the promise, that is the indemnifier, is making a promise to the other party, that is the indemnified. And what promise is he making? What promise is he making? That I will make good the loss that you may suffer, right? I will make good the loss that you may suffer. Now when I say loss, which loss am I talking about? Due to the fault of party 1, that is the party who is making the promise, or due to the fault of any third party, right? So I will make good the loss that you may suffer due to me or any other third party. I will make good that loss. The party who is making the promise is known as the indemnifier, and the party to whom the promise is made is known as the indemnified, right? The party to whom the promise is made is known as the indemnified. So that means I can say a contract of indemnity has 2 parties, right? A contract of indemnity has 2 parties. One who makes the promise, that is the indemnifier. The other to whom the promise is made, that is the indemnified. So what are the rights of the indemnified? What are the rights of the indemnified? If because of any suit he suffers any damages, right? What do we mean by this cost? What do I mean by these damages? Let us say a suit is filed against P2, okay? Against P2 a suit is filed. Now when a suit is filed, first of all, if a suit is filed against me, I have to hire a lawyer, right? I have to go to the court, I have to hire a lawyer. So that costs money. It doesn't come free of cost, right? So whatever cost the indemnified had to pay for that suit, he can recover it from the indemnifier, right? Whatever money he had to pay for the suit, that is the cost of the suit, he can recover it from the indemnifier, right? I repeat again, whatever, because of that case which has been filed, whatever cost has been suffered by this person, that is the indemnified, he can recover it from the indemnifier. Second, if the indemnified, let me say P2 so that you don't get confused, if P2 had lost that case, okay, if P2 had lost that case, then he would have to pay something to the other party. So whatever damages he had to pay, that also he can recover. Right? I repeat again, if a case was filed against P2 and he had lost that case. So when I say lost that case, means he had to pay something to the other party who had filed the case against him. So that damage also he can recover. So what are the rights of the indemnified? He can recover the damages, he can recover the cost of the suit. He can claim compromise paid under any suit. Now what is this compromise paid under any suit? Let us say P2 makes a settlement with the other party outside the court. The other party who wanted to sue him makes a settlement with P2, that is the indemnified, outside the court. Let's not go to the court. It will the only thing that I'll get is tariq pe tariq, tariq pe tariq, right? I would not get any verdict for years. I'll just get dates pe dates, dates not that dates. Okay, so I'll just get the dates. So rather, let us make a settlement outside the court. So when they make a settlement outside the court, whatever compromise was paid by P2 to this third party, he can recover that also from P1. So I repeat again, what are the rights of the indemnified? If a suit was filed against the indemnified, whatever was the cost of the suit, he can recover that. If he suffered any damage in that suit because he lost the suit or whatever, if he suffered any damage, he can recover that. And if the settlement was made outside the court, right? If the settlement was made outside the court, whatever compromise he had to pay, that he can recover. I hope it's clear. Contract of indemnity is clear to everyone. Can we move on to the next one? Contract of guarantee. What is contract of guarantee? What do I mean by contract of guarantee? Now, this word guarantee, if I just give meaning to this word guarantee, it means an assurance. So when we say guarantee or a contract of guarantee, it is an assurance given by one to another person, right? So I repeat again, when I use the word guarantee, to put it in simple terms, the word guarantee means an assurance. So similarly, when I say guarantee in concern to a contract or in relation to a contract, it means the same thing. It is an assurance given. So what is a contract of guarantee? A contract of guarantee is a contract to perform the promise or discharge the liability of another in case he fails to do so. In case he fails to do so. So I make a promise to another person that if the third party does not pay you, or if the third party fails to perform, I will perform or I will pay you. Right? I repeat again. So what is a contract of guarantee? It is an assurance given by one person to another that in case the third party does not pay on time or does not perform the contract on time, I will pay on his behalf or perform on his behalf. This is a contract of guarantee. Right? A contract of guarantee is a contract to perform the promise or discharge the liability of a third party in case of his default. So please understand, the liability arises only when he makes a default. Please understand, the liability arises only when he makes a default. Otherwise, I am not liable to pay. I am only liable to pay when he makes a default. I am only liable to perform when he makes a default. Remember this application will be coming in a little while, okay, this whole thing. So basically let us say A has taken a loan from B. So A becomes the debtor and B becomes the creditor, right? I repeat again, A had taken a loan from B. So A is the debtor and B is the creditor. We call him as the principal debtor. Why? Because he is mainly liable to pay. Now please understand, just because you go and say someone give me a loan, he will not look at your face and give you a loan. He will say give me some assurance that I should give you a loan. I also need some security, right? I need a security that okay, my money is safe. So A takes C and says to B that C, if I don't pay the money, C will pay you the money. So can I say C is giving an assurance to this person B that if A fails to pay, I will pay you? Yes or no? So this is a contract of guarantee. This is what? This is a contract of guarantee. And this is a contract of guarantee, whereby one party gives an assurance to another that he will discharge the debt if this person fails to do so. Right? He will discharge the debt if this person fails to do so. This is a contract of guarantee. I hope it's clear to everyone. So what is a contract of guarantee? Whereby one person gives an assurance to another to perform the contract or discharge the liability of another if he fails to do so. So A has taken a loan from B. So this person C is giving an assurance to B that if A fails to pay, I will pay. This is a contract of guarantee. Now what here it's a tripartite contract. In fact, if you see here, we have three parties involved. Tripartite contract. Why? First is the person who is primarily liable to pay. So we call him as a principal debtor. Then is the person who has given the assurance, who is secondarily liable to pay. That is the surety. We call the guarantor surety. Right. So I repeat again, this C who has given an assurance to pay on behalf of A, he is liable if A defaults. So we cannot say that he is primarily liable. Who is primarily liable? A. So that is why we call him as the principal debtor, because it is his duty to pay on the due date. Now if he fails to pay, if he fails to pay, then C will pay. So C has a secondary liability, and the third party is the creditor to whom the assurance is given. So basically the principal debtor is the person on whose behalf the assurance is given, the surety is the person who gives the assurance, and the creditor is the person to whom the assurance is given. So the surety gives an assurance to the creditor that if the principal debtor fails to pay, I will pay you, or if the principal debtor fails to perform, I will perform. I hope it's clear. So one thing that is very important to be understood here is that it is first the principal debtor's obligation to perform or pay, and only if he fails to perform or pay, then I go to the surety. Right? Now, so if I see these points, I get one essential of a contract of guarantee, that it's a tripartite contract. There are three parties involved. Right? The second thing that I get is the liability is secondary. The second thing that I get is liability is secondary. I already explained this concept. Now please understand, on the due date, can the creditor directly go to the surety? No. No. He cannot directly go to the surety. Can he directly go to the surety? No. No. The creditor must go to the principal debtor. The creditor must first on the due date go to the principal debtor. I repeat again, on the due date the creditor must first go to the principal debtor. If the principal debtor defaults, then he will go to the surety. So because see, in case of his default, I am not liable to pay. I am liable to pay when he defaults. So on the due date, the creditor cannot directly come and sue me. He has to go to the principal debtor. If the principal debtor fails to pay, only then he can come to me for the payment. I hope it is clear to everyone. Yes, so that is the reason we say that the liability of the surety is secondary and conditional. Right? The liability of the surety is secondary and conditional. Now, what will be the liability of the surety? What will be the liability of the surety? Please understand, I am liable on behalf of the principal debtor. Right? I am liable on behalf of the principal debtor. So I can only be liable for what the principal debtor is liable. Right? I repeat again, what is the nature or what is the extent of liability of the surety? Please understand, I am liable on behalf of the principal debtor. So I can only be liable for what the principal debtor is liable. So can I have a more liability than the principal debtor? No. Principal debtor is liable for 1 lakh. What is my liability? 1 lakh maximum. Can I be liable only for 80,000? Yes. Can I be liable for 70,000? Yes. Can I be liable for 1 lakh? Yes. Now the creditor says, since you are the guarantor, you are the surety, you will be liable for 1 lakh plus 10% interest. The principal debtor is liable for 1 lakh. The creditor tells me, since you are the surety, you will be liable for 1 lakh plus 10% interest. Now when the principal debtor is not liable for this 10%, how can I be liable? So the liability of the surety is coextensive to the liability of the principal debtor. I repeat again, the liability of the surety is coextensive. It is coextensive, it is to the same extent as the liability of the principal debtor. So it can be less, it can be equal, but never more. So the liability of the principal debtor is coextensive with the the liability of the surety is coextensive with the liability of the principal debtor. His liability will be less or equal, but not more. Correct? It can never be more. Now, what are the different types of guarantees that we have? I'm going to just give you two examples. Understand carefully. A says to B, sell these goods on credit to C. A says to B, sell these goods on credit to C. If he fails to pay, I will pay. Right? A says to B, sell these goods on credit to C. If he fails to pay, I will pay. Here, A is giving an assurance to B that sell these goods to C on credit, and if he fails to pay, I will pay. This is what? It's a single transaction. It is for a single transaction, right? Whereas if A says to B, whatever goods you sell on credit to C, if he fails to pay, I will pay. Right? A says to B, whatever goods you sell on credit to C, if he fails to pay, I will pay. So here A is not giving a guarantee for a particular goods or particular transaction, but he is giving over a series of transactions. Right? When the guarantee is given for a specific transaction, a particular transaction, we call it as a specific guarantee. Right? We call it as a specific guarantee. On the other hand, when the guarantee is given for a series of transactions, right? For a series of transactions, we call it as a continuing guarantee. So guarantee is of two types, specific and continuing. When it is given for a specific transaction, a particular transaction, we call it as a specific guarantee. But when it is given for a series of transactions, we call it as a continuing guarantee. Right? Now let us say A says to B, whatever goods you sell on credit to C, right? Whatever goods you sell on credit to C, if C is unable to pay, I will pay. If C is unable to pay, I will pay up to 5 lakh. Right? I repeat again, A says to B, whatever goods you sell on credit to C, if he fails to pay, I will pay up to 5 lakh. Even this is continuing guarantee. Even though he has restricted the amount, but it still moves over a series of transactions, so it is still a continuing guarantee. So even if it is restricted by a certain amount, or even if it is restricted by time, right? Time bound or amount bound, but if it is over a series of transactions, it is still known as a continuing guarantee. Correct? So I repeat again, what is a specific guarantee? It is for a particular transaction, whereas continuing moves over a series of transactions. Please understand, specific is for a particular transaction. I have already given the guarantee, on that basis the credit has already arisen, right? Now can I take back my guarantee? Can I now go and say, okay, I am not liable, Can I do this? Come on, dude, that person had given that guarantee, given that credit because of me, right? Because of my guarantee. Can I revoke it now? No. I repeat again, please understand, I had given the guarantee, the credit had already arisen. Now I go and say, I take back my guarantee, I am not interested. Can I do this? Obviously not. Because why I cannot do it is because on the basis of my guarantee, the other person had already given the credit. So now I cannot take it back. So a specific guarantee cannot be revoked, right? A specific guarantee cannot be revoked. But in case of a continuing guarantee, can it be revoked? Yes, I can give a notice that I don't want to be liable anymore. I can just go and say, okay, I'm not liable. But this happens only for the future transactions, For the past transactions, I continue to be liable. So in case of a continuing guarantee, can I just go and announce, oh, okay, I am not liable? Yes. But when I make this announcement, my liability ends for the future transactions, not for the past transactions. So continuing guarantee can be revoked with respect to future transactions, right? With respect to future transactions. So what is a specific guarantee? It is for a particular transaction. Saying that it is for a specific transaction kind of is like, it's like a cycle. saying specific guarantee, specific transaction, rather I would say for a particular transaction, right? So it is for a specific transaction, cannot be revoked, and this is moves over a series of transaction, can be revoked for future transactions, right? Can be revoked with revocation can be done, but with respect to future transactions. I hope it's clear to everyone. Yes. Now, what are the rights of the surety? The surety shall have rights against the principal debtor as well as against the creditor. He also has rights against his co-sureties. He also has rights against his co-sureties. So, anyway, first of all, we will talk about that later. First of all, what are the rights of the surety against the principal debtor? You remember who's the principal debtor, on whose behalf he had given the guarantee, right? On whose behalf he had given the guarantee. So, what are the rights against this principal debtor? First of all, right of indemnification. Indemnify. Remember the previous contract. I have paid on your behalf. I have paid on your behalf. I should get my money back, right? I have paid on your behalf. I should get my money back. So, whatever I have paid, please give me back. So, if the surety has paid on behalf of the principal debtor, now he can recover it from the principal debtor. And rights of subrogation, basically see what happens is, when the surety pays off the creditor, okay, when the surety pays off the creditor is out of the picture, but the liability of the principal debtor is not over. The surety steps into the shoes of the creditor. Yo ma'am, he says you open your shoes. Steps into the shoes of the creditor means, as far as the principal debtor is concerned, the surety is now the creditor and he gets all the rights of the creditor. So, what is this rights of subrogation? He acquires all the rights of the creditor. He steps into the shoes of the creditor. He acquires all the rights of the creditors. As in, he has a right to, to get any security if the creditor had taken. He has a right to get his money back. All the rights that the creditor has, right? What are the rights against the creditor? Right to set off. Set off, if you know, basically set off means when it is a mutual indebtedness. That means I have to pay as well as receive from you. So, if the debtor had to pay the creditor, but it could so happen that the creditor also had to pay the debtor. This is known as mutual indebtedness, when we both are the debtor and creditor to each other. I am your debtor as well as your creditor. So, in that case, will I first pay and then you will pay? No. Rather, the smaller amount we will set off. Right, the smaller amount we will set off. So, let us say this is the debtor, this is the creditor and this is the surety, right. The creditor had given 2 lakh to the debtor. The debtor had also given 50,000 to the creditor. So, when the surety pays the money to the creditor, can he just pay 1.5? Yes. Yes. So, any debt which the debtor has against the creditor can be set off by the surety. So, he has a right to set off any amount that the creditor had to pay to the debtor can be set off. And the next one is right to securities. See, when the creditor gives a loan, he can ask for some security. When I give human as a security, it is known as guarantee. When I give things as a security, it is known as pledge, right? Now, let us say the creditor, apart from the guarantee, he had also taken some goods as a security. Let's say a necklace, right? So, when the surety has paid off the money, the rights of subrogation applies, that is, he steps into the shoes of the creditor. And if the creditor had taken anything also as a security from the principal debtor, the surety will have a right over it. What does this mean? Now, let us say the debtor had taken a loan of 15 lakh from the creditor, for which S had given a surety, right? Apart from this, the debtor had also given a neck piece, okay? The debtor had also given a neck piece of rupees 12 lakh to C. So, can we say he has a guarantee as well as a pledge? Yes. Now, when the creditor gets his money back, he tries to act smart. He is like, okay, debtor, I have got my money back. Let me give you, from the surety, let me give you your necklace. Can he be that smart? No. Now, this necklace belongs to the surety. So if the creditor had taken any security of goods from the principal debtor, the surety, when he pays off the creditor, also has a right over this security. So the creditor cannot return it to the debtor, rather this now belongs to the surety unless he receives his money. So he has a right of securities. In case of guaranteed debts on payment by surety, he gets the right over the securities held by the creditor. I hope it's clear. So I repeat again, what are the rights of the surety? Against the principal debtor, he has a right of indemnification to get back the money he has paid, and rights of subrogation. That is, he gets all the rights of the creditor. Against the creditor, first he has a right to set off. That is, if the creditor had to pay some money to the debtor, that amount can be set off by the surety. And he has a right to securities. That is, if the creditor had taken any security on the debt, then the surety, when he pays off the debt, has a right over that security. I hope it is clear to everyone. Yes. Can we move to the next topic? Yes. So when is the surety discharged? Discharge means he is no longer liable, right? Discharge means he is no longer liable. The surety is no longer liable. There are three cases here. First is in case of revocation, second act of the creditor, and invalidation of the contract. Especially this act of the creditor is quite important when it comes to a practical case. So let's move on to revocation by notice. If you remember, we had discussed about giving a notice. So when we talk about notice, specific guarantee cannot be revoked. Continuing guarantee can be revoked with respect to future transactions. Death, obviously, death operates as a revocation of continuing guarantee. The moment the surety is dead, he will obviously not be liable for the future transactions. However, for the past transactions, he is not personally, obviously he is not, his legal heirs are not personally liable, but his property shall be liable. To the extent of the property will be the liability. So the estate of the surety shall be liable for the transactions before his death. However, and in case of specific guarantee is the same, guarantee will not be revoked, but his property will be liable. You have done all this concept in case in your CA foundation, where you had talked about the liability of a deceased. His legal heirs are never personally liable, it's against his estate. So similarly here also, continuing guarantee, if the surety is dead, the guarantee is revoked for the future transactions. For the past transactions, his estate will be liable. Similarly, for specific guarantee, obviously it cannot be revoked. However, his estate will be liable. Novation means, if I use the word novation means substituting a new contract for a old one. So we are making a new contract in place of the old one. So what exactly is novation? What exactly is novation? So let us say S had given a guarantee to C on behalf of D, right? S had given a guarantee to C on behalf of D. Later he says that due to some reasons, whatever reason, I will not be able to pay the debt. So instead of me now, G gives the guarantee, right? I repeat again, S had given a guarantee to C that he would pay the debt in case D fails to pay. Now what happens is, suddenly he says, I am not in a position to pay the debt, some whatever reason. So he says, instead of me, now G will pay the money. So can we say the old contract of D, C and S has been cancelled and a new contract, obviously if D and C agree, a new contract is made between D, C and G. Yes, this is novation, and S is discharged for the liability under this contract due to novation. I hope it's clear. S is discharged under the contract due to novation. I hope it's clear to everyone. Yes. So novation. Now moving on to the next one, the act of the creditor. As I already told you, an important part. Variation in the terms of the contract. Now please understand, I am giving you the guarantee. Okay, I am the surety, I am giving you the guarantee. So I am also liable on this contract. So if you make any changes to the contract, you should inform me. If you fail to inform me, I am discharged. The debt was supposed to be paid after 1 year. You make a contract and extend the time to 2 years. You should inform me. If you don't inform me, I am discharged. The debt was supposed to be paid in 1 year, right? It was supposed to be paid in 1 year. You say pay it in 6 months. you and the debtor, you agree that pay it in 6 months. You should inform me because I am also liable. You fail to inform, I am discharged. Right? Amount pay supposed to be paid was 15 lakh. You and the debtor agree that instead of 15 he will now pay 12 lakh. You should inform me. You did not, I am discharged. The rate of interest was 10%. You make it 12%. You should inform me. If you don't, I am discharged. You make it 8%. You should inform me. If you don't, I am discharged. But ma'am, it is beneficial to, reduced rate, whatever. They are not talking about beneficial or not beneficial. They say any variations should be informed. So if it is beneficial, not beneficial, that is not even a concern here, right? If it is beneficial, not beneficial, that is not even a concern. If there is a variation, any variation, you should inform me. If you do not inform me, I am discharged, right? So terms varied without the consent of the surety, discharge for contracts after variations, right? Discharge for contracts after variation. After the variation is done, I am not liable. Release of the principal debtor. See, I am liable only because the principal debtor is liable. I am liable only because the principal debtor is liable. If you absolve the principal debtor from liability, you say, okay, principal debtor, you are no longer liable. Obviously, I will never be liable then. I am liable only because my liability is coextensive to the liability of the principal debtor. My liability is coextensive to the liability of the principal debtor. If you release the principal debtor, if you say, okay, you are no longer liable, how will I be liable then? I am never liable then. So let us say A hired B to build a house. Okay, A hired B to build a house for him and material to be supplied by A. If you remember something like this, you had done reciprocal promise also. A hired B to build a house for him, material to be supplied by A. This is, can I say, reciprocal promise? Yes or no? B will perform only when A performs. Only when A gives the material, B will build the house, right? C had given a guarantee for this contract. Ma'am, guarantee for this contract? Yes, that B will build the house, and if he fails to build the house, I am liable for it, right? If you remember, the definition was to perform the promise or discharge the liability. It is not only for a loan, it is also for the performance of the contract. So I repeat again, A hired B to build a house for him, material to be supplied by A, and C gives a guarantee for this, that if B does not build the house, I will do it. Now A only did not supply the material. A only did not supply the material. So in reciprocal promise, if one party prevents the other from performing, can I say B is also discharged? Yes or no? B is discharged because if A does not supply the material, how will B build the house? So B is also discharged. Now when B is discharged, tell me, when B is discharged, can A go and sue C for non-performance? No, because when B is discharged, C is automatically discharged. When B is discharged, I am liable only because the principal debtor is liable. If principal debtor's liability is nil, I am obviously not liable at all. So if the principal debtor is released of liability, the surety is also discharged. If a discharge of debtor by operation of law, surety is not discharged. What does this mean? Now let us say in this case, okay, in this case, let us say C had given a loan of 15 lakh to D and S had given a guarantee to C, right? Now D becomes insolvent, right? D becomes insolvent. I repeat again, C had given a loan of 15 lakh to D and S had given a guarantee for this. Now this D becomes insolvent. So when D becomes insolvent, can we say D is discharged? Because when a party becomes insolvent by operation of law, discharge, yes. Is S also discharged? No. So where the principal debtor is released from liability, the surety is also released. But if the release takes place by operation of law, then the surety is not discharged. Let us say D is dead. Is S discharged? No. If the discharge takes place due to operation of law, the surety is not discharged. I hope it's clear to everyone. Yes, so Very clearly it's written here, if the discharge of the debtor is by operation of law, surety is not discharged. Correct? Now loss of securities. Okay, remember this neck piece. Remember this neck piece. Ayo, these touch screens, I swear, I swear, I shouldn't be swearing. Anyway, so I am not repeating the example again. So when the surety pays the money to the creditor, okay, can I say he has a right over this neck piece? This example I had already given it to you a while back, so I am not going into that all over again. When S pays off the money to the creditor, can we say he will have a right over that neck piece? Yes or no? Yes. When the surety pays the creditor, he will have a right over that security, right? Now the surety goes to pay the money to the creditor and he says, okay, I am paying you the money, please give me the necklace, right? He says, please give me the necklace. The creditor is like, he's like, what? Give me the necklace. What happened? You know, my wife, she saw the necklace, and you know how females are. She fell in love with the necklace, and you know, I told her this is not yours, but she was like, I have to wear it. Yeah, so you listen, no. So you know, no, my wife, she's so negligent. I swear, I don't know how I'm managing, how she's so what happened? No, she wore that necklace, she tied it. As per her, she put that, you know, she put that clutch. But the clutch was not properly put, and when we were going out, the necklace fell somewhere. So I don't have the necklace. Now the surety says, okay, fine, I will not pay you 12 lakh rupees, I will only pay you 3 lakh. I will not pay you the full 15 lakh. The value of the necklace was 12 lakh rupees, I will deduct that and I will only pay you 3 lakh. Can he do that? Yes. If the creditor loses the security that he had taken from the debtor, if the creditor loses the security that he had taken from the debtor, the surety is discharged up to the value of the security. The surety is discharged up to the value of the security, correct? So, if the creditor loses or without consent of surety returns any security, the surety is discharged to the extent of the value of the security. Composition with the principal debtor. What do we mean by composition? If the principal debtor and the creditor, they make any composition, they give time or they agree not to sue and fail to inform the surety, right? And they fail to inform the surety is discharged. What does this mean? If the principal debtor, so this contract is between, this will be creditor, okay. Now the contract is between the creditor and the principal debtor, where the creditor and principal debtor makes composition. What is composition? I had to pay you 15 lakh. You say, okay, in full settlement pay me 10 lakh. This is composition, right? You should inform the surety or not. Yes, if you don't, he is discharged, right? I repeat again, there is a contract between the principal debtor and the creditor that the principal debtor will pay a lesser amount in full settlement, and they do not inform the surety. The surety is discharged. They do not inform the surety is discharged. Then let's or the principal debtor and the creditor have a contract where extra time is given. 1 year, instead of 1 year you pay after 1.5 years. The surety should be, this is overlapping. If you see alteration in the terms of the contract, it is kind of overlapping with this to some extent in some cases. So when you are giving extension of time, you should inform the surety because he is also liable. You fail to inform, discharged. Agrees not to sue. The debtor, the creditor, the surety, right? The debtor and the creditor agrees that the creditor will not sue D. He says, okay, fine, no problem. I will not sue you. Come whatever may, if you don't pay, I will not sue you. They should inform the surety also, no? If they fail to inform the surety is discharged. So if there is a contract between the creditor and the principal debtor where they make a composition or agrees to give time or agrees not to sue, and the surety is not informed, the surety is discharged. surety is not informed or he does not agree, the surety is discharged. Now just not something relating to this, a little different, please listen to what I am saying. Okay, DCS, already know what it is. Now this person X, who is a third party, this person X, who is a third party, goes to C and says to C, please do not sue D. Come whatever may, if D pays, if D does not pay, do not sue D. Come whatever may, do not sue D, right? So I repeat again, C, D, S, C is the creditor, D is the principal debtor, S is the surety. X, a third party, goes to C and says to C, whatever happens, please do not sue D, right? And C agrees. Okay, and C agrees. And C agrees. And C agrees. So my question is S discharged? Is S discharged? So C and X agree that C will not sue D even if D fails to pay. Is S discharged? No. No. Please understand, here there should be a contract between the creditor and the principal debtor. Here agreement not to sue is between C and X. C is the creditor but X is not the principal debtor. The agreement is not between C and D. Only when the agreement is between C and D and surety is not informed, then surety is discharged. Here the agreement is between C and X, who is an outsider. So S is not discharged. I hope it's clear to everyone. Yes. And the last one, creditor impairs surety's rights against the principal debtor. This is the same as this one only. Let us say he had taken the neck piece. So can I say when S makes the payment, can I say when S makes the payment, he has a right over this neck piece? Yes or no? Now when C, what he does is he returns this neck piece to D. So I repeat again, S had a right over this neck piece, but when C returns the neck piece to D, he is, can we say, affecting or hampering the right of S over this neck piece? Yes or no? Yes. So when the creditor hampers the rights of the surety, when the creditor hampers the rights of the surety over the principal debtor, he is discharged to that extent. He is discharged. As you can see, these are overlapping. To some extent, these are overlapping provisions. Yes. So any act of the creditor which takes away the surety's rights on the principal debtor shall discharge the surety to that extent. I hope it's clear to everyone. For practical questions, this topic is a little important. So the next one, the invalidation of the contract. Now, if the guarantee is obtained by concealment of material facts. Material fact means those facts which can affect the decision of the surety as to whether he should be a surety or not. Now all those facts have to be disclosed. All those facts have to be disclosed. If I get a guarantee without disclosing those facts, the surety is discharged. So if the guarantee is obtained without disclosing the material facts, not just any fact, the material which would actually affect the decision of the surety. If it is obtained without disclosing the material facts, then in that case what will happen is the surety is discharged. Then failure of consideration, if between the principal debtor and the creditor there is no consideration. Obviously no consideration, no contract. So if there is no consideration between them, automatically this contract is void. So if this contract is void, the contract of surety is also void. And if one of the co-surety fails to join. Now let us understand what is a co-surety. When more than one person gives the guarantee, right? When more than one person gives the guarantee. So when we say co-surety, let us say S1 and S2 have given a guarantee, right? S1 and S2 have given a guarantee. So they are known as co-sureties. Now please understand, co-sureties are just like joint promisors. So if one of them pays on behalf of the others, he can also recover from the other the share that he was supposed to pay, right? This is a right of the co-surety. If one of the co-sureties has paid on behalf of the other, he can actually recover from the other his share. So the same rights as in the case of joint promisor applies here. Now if let us say S1 signs the guarantee agreement with a condition, signs writing liable only when S2 signs, right? Now what S1 did was, he was very sure that this S2 will not sign and I will alone be liable. So what he does is, he puts his signature, but under his signature he writes, I am liable only when S2 signs. Now if S2 does not sign, can we say S1 is discharged? Yes or no? Yes. Can we say S1 is discharged? Yes. So if the guarantee is given on the condition that surety shall be liable only when the other person joins, if such person fails to join, the surety is discharged. I hope it's clear. Yes, I hope it's clear. Now, so what is co-surety? Where it is guaranteed by, and if one of them pays, he can recover it from the other. So I hope the whole of guarantee agreement is clear to everyone. We are done with the contract of guarantee. I hope it's clear to everyone. Yes. Can we now move on to the next topic? Yes. Okay, so moving on to the next one, contract of bailment. Bail, jail, no connection. Okay, so what is a contract of bailment? Here basically delivery of goods is taking place. Okay, the possession of the goods are transferred. So one party is delivering the goods, transferring the possession of the goods to another party. Now why is he doing that? Just no reason. Ayo, nothing to do, let us do transfer of goods. No. Obviously the transfer of goods is taking place for some specific purpose, right? Why is the transfer of goods taking place? For some specific purpose. I have some reason I am giving you the goods, and once the purpose is accomplished, can the other party keep the goods with himself? No. He must either return the goods back or he must dispose of the goods as per the directions of party 1. So what is a contract of bailment? A contract of bailment is a contract whereby one party transfers the possession of the goods to another for a specific purpose, and once the purpose is attained, the goods have to be returned back or disposed of in the manner warranted. So what does it mean? Let us say you have borrowed a book from the library. Once you have read the book, you have to return it back. This is contract of bailment, right? On the other hand, you have to dispatch some goods. You want to send some goods. I am going to send my pendrive classes to you. I am going to courier the books to you. So there is a contract between me and the courier company. They have to dispose of the goods at your place as per my direction. This is what contract of bailment. So one thing very much clear is, first, that possession of the goods is transferred, not the ownership. Second, the goods cannot be kept by the second party. If it is kept by the second party, it is not bailment. The goods must be returned back or the goods have to be disposed of. Right. So I repeat again, what is contract of bailment? One party transfers the possession of the goods to another party for a specific purpose, and once the purpose is attained, the goods have to be returned back or disposed of in the manner specified. The person who gives the goods is the bailer, and the person to whom the goods are given is the bailee. So what are the features of bailment? What are the features of bailment? First of all, there have to be goods, and when I say goods, goods means only movable goods. Bailment can never be for immovable goods, right? Then there should be some delivery of the goods. Bailment can never take place without delivery. Delivery need not be actual, it can be symbolic, constructive, anything, but delivery has to happen. Without delivery, bailment cannot take place. The delivery may be actual, symbolic, constructive, whatever, but delivery has to take place, and it should result in possession and not mere custody. The delivery should result in the possession of the goods, not just custody. What is this possession and not just custody? When you park on the roadside, it is not bailment. It is not, because the keys are with you. The possession is not given to the other person, right? Whereas when you go for a valet parking, they have the car keys also with them only. It is, they have the possession of the goods, not just custody, right? They have the possession, not just custody. And you must have referred to the case of Kalia Perumal versus Visa Lakshmi Achi, where the lady, she went to the goldsmith, she gave her box of gold jewelry to the goldsmith, but she used to lock it every night and take the keys away. Every day morning she would come back, open the box with her own hands and then give it to the goldsmith to make new jewelry. since the key was with her, it was only custody of the box that the goldsmith had and not the possession. One day she opened the box, nothing was there. She claims the money from the goldsmith. Is the goldsmith liable? No, because there was no bailment, because he only had the custody, not the possession. Possession means the right to access the goods. Possession means the right to access the goods at any given point of time, right? So there should be some transfer of possession and not mere custody. And finally, goods have to be returned back or disposed of. If the goods are retained by the second party, it is not bailment. I already explained it to you. I repeat again, if the goods are not returned back, it is not bailment. For bailment, the goods have to be disposed of or has to be returned back. If it is kept with the other party, it is not bailment. I hope it is clear to everyone. Can we move on to the next point? Yes. Now we have two types of bailment. Okay, we have two types of bailment. It could either be gratuitous or non-gratuitous. Gratuitous means it's out of gratitude. So I am not taking any consideration for the bailment. Whereas non-gratuitous means it is always for some consideration, right? I repeat again, bailment may be either gratuitous or non-gratuitous. Now when we say gratuitous means there is no consideration involved. It's out of gratitude. Gratuitous, gratitude. So that's how we remember. So when we say gratuitous bailment, that there is no consideration involved. On the other hand, if it is a non-gratuitous bailment, there would be some consideration involved. For example, I give the courier company the books to be couriered to you. Obviously, I am getting some return, they are getting some return. They are not going to deliver the books free of charge, right? So they will get the money for it and my job is done. So it is for the benefit of both of us and I am giving consideration to them, right? And they are getting consideration and I am getting in return the delivery of the books to you. So this is a non-gratuitous bailment. On the other hand, when it is a gratuitous bailment means it's not for consideration. So when it is not for consideration, obviously both the parties are not on the receiving end. So when both the parties are not on the receiving end, it will be always for the benefit of only one party. So it can be either benefit of the bailer or the benefit of the bailee. Benefit of the bailer, benefit of the bailee. Let us say you are going for a vacation and you have a puppy and you cannot take your puppy for this vacation. So you ask your friend to take care of your puppy. So this is for the benefit of you. You are giving the goods. So this is the benefit of the bailer. On the other hand, your friend missed out his classes. So he says, could you please lend me your notes? I will copy and give it to you. Now tell me, will your friend charge you money for taking care of the puppy? No. Will you charge money from your friend for lending him the book? No. Here it is for the benefit of the person who is taking the notes. That is the bailee. So it is for the benefit of the bailee. So when it is gratuitous, it is without consideration. It can never be beneficial to both. So it can be either for the benefit of the bailer or for the benefit of the bailee. And so I repeat again, what is gratuitous? No consideration. It can be either for the benefit of the bailer or the benefit of the bailee. And what is non-gratuitous? For consideration, there is a mutual benefit of both the parties involved. Now what are the duties of the bailer and the bailee? Now this bailer and bailee have some duties over the goods. You can get practical questions from these topics. So what are the duties of the bailer? Now one thing very important to understand here is, if you remember, the right of one becomes the duty of another, right? The right of one becomes the duty. In a contract, if you remember, what is my give is your take and what is your take is my give, right? My right is your obligation is my right, right? I repeat again, my right is your obligation and my obligation is your right. This happens in a contract, right? It is a relation where my rights is your obligation and vice versa. Now, please understand, when we say duties of bailer, it automatically becomes, the rights of the bailee. Because the duty of bailer is equal to the rights of the bailee and vice versa, right? So when we say duties of the bailer, it is automatically the rights of the bailee, right? So if you get a question like, what is the right of the bailee? Oh my god, I have never studied it. The duties of the bailer is the same. What are the duties of the bailer? The first duty is to disclose the known faults. If I am giving you my goods and there are some defects in the goods, I am supposed to inform you. My puppy is vicious. If someone touches his head, he gets really, he fires up. He's ready to, chew the other person down. So I should inform this. So if there are any faults in the goods, it is the duty of the bailor to inform the bailee about the goods. If he fails to do so and the bailee suffers any damage, he can claim it from the bailor. If he fails to disclose the facts and the bailee suffers any damage, he can claim those damages from the bailor. Right? Now here there are two concepts. If the contract is a gratuitous contract, it is not for consideration. Now if there, please understand, there could be defects which are known to the bailor, there could be defects which are not known to the bailor. The goods have some defects, but the bailor is unaware of those defects. It could happen that there are some defects, but the bailor is unaware of those defects, right? So if the bailment is a gratuitous bailment, that is, it's not for consideration, then the bailor is only liable for the faults that he was aware of, right? But if it is a non-gratuitous bailment, dude, I am paying you money for it. You are responsible for your goods. Any defect, I did not know, I don't care a damn, you did not know. It was your duty to know. You are responsible for both known and unknown faults. Because I am paying you money for it, you are responsible for your goods. So if there are any defects in your goods, it's your duty to know about them. It is your duty to know about them. So I repeat again, when we talk about faults in the goods, if it is a gratuitous bailment, he is liable for the known facts, whereas if it is a non-gratuitous bailment, he is liable for both the known and the unknown defects. So if it is a non-gratuitous bailment, he is liable for both known and unknown faults, whereas if it's a gratuitous bailment, he is liable for the known faults. So the next duty is to bear extraordinary expenses. What is ordinary? What is extraordinary? Let us say when I give my puppy to you, the ordinary expenses is the food of the puppy, whereas the extraordinary expenses, let's say if the puppy falls ill, so you have to take him to the vet or anything, whatever, you take him to the hospital, whatever you spend, that's extraordinary expenses. Let us say I lend you my car or my bike. The petrol is the ordinary expenses, but let's say if something happens, the engine breaks down and you get it repaired, that is extraordinary expenses. Now what the act is saying is that the bailor, he has to bear the extraordinary expenses. The ordinary expenses shall be borne by the bailee. So let us say when you take a car on rent, okay, you have these Zoom cars and all, so you have to pay the price of the petrol, you have to fill up the petrol. But if something happens to the car breaks down, are you going to pay that charges? No, that will be paid by the Zoom company. But if the bailment is a bailment which is for the benefit of the bailor, that is, it's a gratuitous bailment and it is for the benefit of the bailor, then in that case both ordinary and extraordinary expenses shall be borne by the bailor. So let's say I ask you to take care of my puppy while I am on vacation. It is my duty to pay for his food as well as whatever extra expenses that you incur, right? The next one is to indemnify the bailee for the loss due to premature termination of a gratuitous bailment. Now, the bailment is a gratuitous bailment, and when it is a gratuitous bailment, generally it can be, it is either for the benefit of the bailor or for the benefit of the bailee, right? Now, if the gratuitous bailment is terminated before the term is, or before the time, okay, so in that case whatever damages the bailee has suffered, the bailor has to compensate for that. Let us say, for example, I have a bike, I have one extra bike and I say I am not using it, so you just take the bike and you keep it for the next 6 months, but it has to be repaired, so you pay the charges of the repairing. You take the, anyway you are happy because you don't have to buy the bike, you don't have to pay me any rental charges, you take the bike. Now you pay for the repairs and everything, and I had given it to you for 6 months, but after 2 months I come and say, hey, please give me my bike back. So you had spent money in the hope of using it for 6 months, but after 2 months I am claiming the bike back. So that means, can we say the expenses which were supposed to be used for 6 months are now used only for 2 months? So can you claim those damages? Yes. So if the gratuitous bailment is terminated prematurely, that is before the time period, in that case whatever damages the bailee has suffered, he has a right to claim it from the bailor. So the next duty is to bear extraordinary expenses. What is ordinary? What is extraordinary? Let us say when I give my puppy to you, the ordinary expenses is the food of the puppy, whereas the extraordinary expenses, let's say if the puppy falls ill, so you have to take him to the vet or anything, whatever, you take him to the hospital, whatever you spend, that's extraordinary expenses. Let us say I lend you my car or my bike. The petrol is the ordinary expenses, but let's say if something happens, the engine breaks down and you get it repaired, that is extraordinary expenses. Now what the act is saying is that the bailer, he has to bear the extraordinary expenses. The ordinary expenses shall be borne by the bailee. So let us say when you take a car on rent, okay, when you have these Zoom cars and all, so you have to pay the price of the petrol, you have to fill up the petrol. But if something happens to the car breaks down, are you going to pay that charges? No, that will be paid by the Zoom company. But if the bailment is a bailment which is for the benefit of the bailer, that is, it's a gratuitous bailment and it is for the benefit of the bailer, then in that case both ordinary and extraordinary expenses shall be borne by the bailer. So let's say I ask you to take care of my puppy while I am on vacation. It is my duty to pay for his food as well as whatever extra expenses that you incur, right? The next one is to indemnify the bailee for the loss due to premature termination of a gratuitous bailment. Now, the bailment is a gratuitous bailment, and when it is a gratuitous bailment, generally it can be, it is either for the benefit of the bailer or for the benefit of the bailee, right? Now, if the gratuitous bailment is terminated before the term is, or before the time, okay, so in that case whatever damages the bailee has suffered, the bailer has to compensate for that. Let us say, for example, I have a bike, I have one extra bike and I say I am not using it, so you just take the bike and you keep it for the next 6 months, and but it has to be repaired, so you pay the charges of the repairing. You take the, anyway you are happy because you don't have to buy the bike, you don't have to pay me any rental charges, you take the bike. Now you pay for the repairs and everything, and I had given it to you for 6 months, but after 2 months I come and say, hey, please give me my bike back. So you had spent money in the hope of using it for 6 months, but after 2 months I am claiming the bike back. So that means, can we say the expenses which were supposed to be used for 6 months are now used only for 2 months? So can you claim those damages? Yes. So if the gratuitous bailment is terminated prematurely, that is before the time period, in that case whatever damages the bailee has suffered, he has a right to claim it from the bailer. Now the next duty of the bailer is that when the termination of bailment happens, that is when the bailment is terminated, it's over, the contract of bailment is over, he has a duty to take the goods back. It is his duty to take the goods back. You don't have a place to keep, so you say, no, you keep it, I'll take it later, no problem, no problem. Oh my God, it's just you are just seeing your benefit, not the benefit of the bailee. So if you refuse to take the goods, the bailee has a right to claim compensation from you. And the last one, indemnify bailee for the defects in the title of the goods. If the title of the bailer is defective, let's say the bailer had some stolen goods and now he gave it on bailment to another person, and because of that the bailee suffers losses, can he claim those losses from the bailer? Yes. If due to the defective title of the bailee suffers any losses, he has a right to recover those losses from the bailer, correct? Now what are the duties of the bailee? He has a duty to take reasonable care of the goods. What do I mean by reasonable care? Reasonable care means that care that the owner of the goods would take. I repeat again, what is reasonable care? Reasonable care means that care of the goods that an owner would take, right? So if let us say you have a piece of jewelry, you will not keep it on your dressing table. So if you do that, it is not reasonable care. But if you keep it in your the cupboard or the almirah or the locker, then that is reasonable care. If the bailee has taken reasonable care of the goods and if anything happens to the goods, the bailee is not liable. However, in some cases, even if the bailee has taken reasonable care of the goods, he is still liable for the goods. If the bailer has given specific instructions and the bailee fails to fulfill those specific instructions, I repeat again, if the bailer has given some specific instructions and the bailee fails to follow those specific instructions, the bailer gave a neck piece to the bailee and says to him that please take a bank locker, I will give you the charges, keep it in the bank locker. The bailee keeps it in his locker at his house. He has taken reasonable care of the goods, because that is what an owner would do, keep it in the locker. But he did not follow the instructions of the bailor. And since he did not follow the instructions of the bailor, he is liable for any damage that has happened to the goods. And the second case is that if he fails to return the goods back. If the bailment is over, it is his duty to return the goods back. If he retains the goods even after that, then if anything happens to the goods, even if he takes reasonable care, he is responsible. Right? If the bailment is over, it is his duty to return the goods back. And if he fails to return the goods back, even if he has taken reasonable care, whatever, he is liable for the goods. The second duty is not to make unauthorized use of the goods. When I have given you the goods with specific instructions that the goods can be used only for this purpose, can you make any use other than that? Your friend lends his book to you in the class because you have not bought your book. He is very specific, he is very clear about it. He does not like to use pen in his book. He says, do not mark anything with a pen. And you take red, blue, green, all colors and you start marking with both hands. Dude, seriously, you are making unauthorized use of the goods. So if the bailor has given the goods, and while giving you the goods, he has given instructions as to how the goods should be used, you cannot make unauthorized use. You cannot make any use of the goods against the instructions. Not to set up any adverse title over the goods. You are not the owner of the goods, you are just the bailee of the goods. So can you go and pledge those goods? Can you do that? No. Can you, without the authority from the bailor, sell off those goods? No. You have no right. You can only use the goods for the purpose the goods have been given to you. You cannot use the goods for any other purpose other than the specified purpose. So if you do that, obviously it's your duty, you cannot. Obviously you will be liable to the bailor. Then not to mix the goods with his own goods. He cannot mix goods with his own goods. If he mixes the goods, let's say the bailor and the bailee had a contract that we will mix the goods together. So if they had a contract, we will mix the goods together, then the mixed goods will belong proportionately to each of them. But if there was no such agreement, he cannot mix the goods with his own goods. And if he does so, then in that case, whatever he has to get the goods separated. And whatever expenses is incurred in getting the books separated, he has to pay for that. So let us say I had given you some 10 books and you had some 500 books, you kept those 10 books in that, along with those 500 books. Now I tell you where are my books, you say okay, there are some 550 books in this, you select your books, you check where your books are. I am like, seriously? I say please hire someone to do it for me, these are the names of my books. So those charges for hiring that person to select the books, so that will be paid by the bailee because he has mixed the goods without my authority. On the other hand, the goods mixed cannot be separated. For example, you have mixed mustard oil and olive oil. How can I separate them? Can I put them in oil and olive oil will come up and, come on, seriously, no. So that cannot be separated. So in case the goods are such which have been mixed and now cannot be separated, in that case the bailee is supposed to pay the reasonable charges of the goods to the bailor, right? So with the bailor's consent, both will have proportionate interest on the goods. If it is mixed without the bailor's consent, if they are separable, then get them separated, charged by the bailee. Not separable, compensate the bailor. The next duty is to return the goods back. Obviously, you cannot keep the goods beyond the time specified. So, if the purpose for which the bailment was made is over, it is attained, you have to return the goods back. You cannot retain the goods. So, he must return the goods back and to return any accretion to the goods. So, if the goods multiply, let us say I gave you shares to keep, and while the shares were with you, the company issued bonus shares and you got those bonus shares. Now I come to you and I say, now could you please return my shares back? You are like, yes. I say the bonus shares, oh no, when the shares were with me, I got the bonus shares, so the bonus shares belong to me. Like, seriously? No. If the goods multiply, right, if there is any accretion to the goods, that accretion also belongs to the bailor. Because the goods belong to the bailor, any accretion to the goods will also belong to the bailor. So can the bailee retain the accretion? No, he must return them. So any profit or increase to the goods must also be returned back to the bailor. I hope it's clear to everyone. Yes, now we'll move on to the rights. Ma'am, why rights? Because we've already done the duties is rights, yes, but there are some extra rights also, so let's talk about that. Okay, so apart from, as I said, the duties of the bailior is equal to the rights of the bailee. So when I say rights of the bailee, what are the rights of the bailee? To claim damages for faults in the goods, to claim the extraordinary expenses, to get the damages for any premature termination, then to return the goods back, and if he has to keep the goods beyond the time, to claim damages for the compensation for the same, to get damages for any defect in the title of the bailior, right? And if I say what are the rights of the bailior, to claim damages if the bailee has not taken the reasonable care of the goods, to claim damages if the bailee makes unauthorized use of the goods, and in fact if unauthorized use of the goods are made, the bailior can even terminate the bailment. Then to claim damages for any adverse title which have been set up by the bailee over the goods, then to claim damages, to claim the goods back, and if the goods have been mixed with the goods of the bailee, to claim the return of the goods, or if the goods are not separable, to get the money of the, to get the reasonable price of the goods, to get the goods back, and to get any accretion to the goods. So this is, so you will just have to reverse it as per rights. Now the bailee, apart from these rights, he also has certain other rights. Rights against the wrongdoer and rights of lien. Right, these are the rights of the bailee. Apart from the rights that were specified above, the bailee also has a right against the wrongdoer, and he also has a right of lien. Now what is this rights against the wrongdoer? Now the general concept is that if anything happens to my goods, I have a right to claim the damages for those goods. Correct or not? I am the owner of the goods, and if anything happens to my goods due to a third party, I have a right to claim the damages from the third party. This is the general rule. However, in case of bailment, if the goods have been given to the bailee shall have the same rights over the goods as a bailior for claiming compensation from a third party. That is, if the goods are, I am holding the goods as a bailee for you, and if anything happens to the goods, I have a right to claim the whole money for the goods from the third party as if I am the owner of the goods. Yeah, I have to return it back to you, that's a different case, but I have a right to claim the entire damages as if I have the right of ownership over the goods. So if a third party deprives the bailee from the use or possession of the goods, he shall have all the rights against the third party as if he is the owner of the goods. So if the goods are taken away from me, or if the goods are destroyed, now please understand, deprives bailee from use or possession of the goods, this includes any loss happening to the goods. So if any loss happens to the goods are destroyed, I have a right to claim the money from the third party, even though I am not the owner of the goods. Then he has a right of lien. The word lien means what? Lien means to retain the possession of the goods. Now see, I am doing something for you, and you have to pay me charges for the same. If you do not pay me the charges for the same, I will not give you the goods, right? I send goods to you on by carrier, okay? The goods are in the carrier and I have not paid the carrier charges. I said the bailee will pay the, I said you will pay the carrier charges. Now unless you pay the carrier charges, can we say the carrier company can hold your goods? Yes or no? Yes, this is lien. This is what? This is lien. I repeat again, when the bailee does anything for me, I am supposed to pay him the charges for the work he is doing for me. If I fail to pay the charges, he has a right to retain the goods unless the charges are paid. Right? So when I give the goods to the carrier and I tell them that the other party will pay you the charges, and when they get the goods to you, if you fail to pay the charges, they have a right not to hand over the goods to you unless you agree to pay the charges. So this is what rights of lien. Now when we say rights of lien, lien can be particular lien or general lien. Lien could be a particular lien or a general lien. What is this particular lien? Let us say I have given a tailor 3 shirts to stitch, and now I go to take the delivery of the shirts and I only pay for the 2 shirts. Can I claim all the 3 shirts? No. No. I repeat again, I go to I have given 3 shirts to the tailor to stitch. Now I go to the tailor with the price of 2 shirts and I give him the price and I say give me all the 3 shirts. Is he bound to give me all the 3 shirts? No. Can he refuse? Yes. Can he refuse to give me all the shirts? No. I am paying for 2, he is bound to give me the 2. But I am not paying the third one, he can refuse to pay me for the, hand over the third one. This is particular lien. When a person uses his skill over my goods, and whatever are the charges for that, if I don't pay him, he has a right to retain the goods. But please understand, he can only retain it for that part for which I am not paying. Right? He can only retain it for that part. Can he retain all the 3 shirts? No. But he can retain that 1 shirt for which I have not paid. But can he retain all the 3? No. So this is what? This is particular lien. What is particular lien? That when the bailee uses his skill over the goods and is not paid for that, so he can exercise a lien over those part of the goods for which he has not received the money. But when we say general lien means it is over the general account. Now please understand, general lien cannot be exercised by everyone. General lien is one type of lien which cannot be exercised by everyone. General lien can be exercised only by banks or CAs, such professionals, only by them. General lien means what? They have a lien over your general account. They have a lien over your general account. Now let us say you have 2 fixed deposits with the bank, and against the security of 1 fixed deposit you have taken a loan, right? So can I say unless you pay that loan, they will not hand over that fixed deposit to you? Correct? I repeat again, you have 2 fixed deposits with the bank, and against one of the fixed deposits you have taken a loan. So can I say unless you repay the loan, they will not hand over this to you, that they will not hand over this fixed deposit amount to you? Correct? But can they also exercise a lien over the second fixed deposit? Can they also exercise a lien over the second fixed deposits? Yes. In the case of the tailor, he couldn't retain the 2 shirts for which you are paying. But in the case of a bank, they have a lien, a general lien, that is a lien over the general balance of the account. So even if the loan was taken against the security of one of the fixed deposits, still the bank can retain the second fixed deposit also unless you pay them. So this is general lien. It's not available to everyone, only banks or CAs, they can exercise this, right? So what is a particular lien? Available only against those goods for which some services have been rendered involving his skill or labor. Retain all the goods of another until all claims of the holder are satisfied, as I said in the case of a bank. I hope it's clear to everyone. I hope it's clear to everyone. Yes, can we move on to the next part now? Now, finder of the goods. Finder of the goods, even if you are done in foundation also, that it's a contract of bailment where the finder of the goods is the bailee of the goods, right? So finder is a bailee of the goods, and all duties and rights of the bailer and bailee also applies here. Apart from that, the finder will also have certain extra rights, right, against the bailer. All the rights and duties of the bailer and bailee obviously is available here also, but apart from that, the finder of the goods will also have certain other rights. What? He has a right to claim the expenses. What do I mean by this? Let's say while trying to trace the owner or while trying to retain the goods with him, he has incurred some expenses, right? I repeat again, let us say the finder of the goods, while trying to trace the owner or while trying to, while trying to keep the goods, he has incurred any expenses. He has a right to claim those expenses. He has a right to claim those expenses. So let's say he put up an ad in the newspaper, or it was a puppy, he was taking care of the puppy, he took the puppy to the vet. So whatever expenses he has incurred, he has a right to claim it. Then he has a right of lien for the expenses. If he does not get his expenses, he can retain the goods unless he gets the expenses. He has a right of sale. This you have also done it. If the goods are perishable, let us say you find 1 dozen oranges or you find 1 dozen eggs, will you keep it? Oh, you no, return it to the finder. Bah, nothing will be left to the return to the owner, sorry. Nothing will be left, only some rotten juices will be left. So if the goods are perishable, it's preferable you sell off the goods. Or if the owner is not found after reasonable search, I did everything that was possible for me, but I still could not find the owner. Or the owner refuses to give the lawful charges, and the lawful charges are 2/3 or more of the value of the goods. I found the owner. I told him, please give me my expenses. He says, I will not give you the expenses. And the expenses are almost 2/3 or more of the value of the goods. Then in that case, I can sell the goods and get my money. For example, let us say the value of the goods is 1000. I spent 200. He did not give me. Can I go and sell the goods? No. Can I sue him for the money? Yes. Can I exercise lien over the goods? Yes. But can I sell the goods? No. On the other hand, the expenses that I incurred was 800. He does not give me the money. Can I exercise a lien over the goods? Yes. Can I sell the goods? Yes, I can also sell the goods. Now, when I sell the goods for 1000, my expenses were 800. I will keep the 800. I have to return the 200 back. Right? If I spent more and I got less, then I will retain the money, and for the remaining money I am going to sue him. I hope it's clear to everyone. Then he has a right to remuneration. What does this mean? Let us say this happens only if a reward is announced. You cannot say, no, first you give me 5,000 rupees, then I will hand over your puppy. No, you cannot do that. You cannot do that. But if the owner had announced the reward that anyone who finds my puppy will get a reward of 5,000 rupees, then if he does not give you, you can claim that reward for that return of the puppy, right? And finally, he has the right of ownership against the whole world except the owner. When you have found goods belonging to another person, you have the same position as the owner of the goods. So tomorrow if someone comes and says, hey, this is fine, you found it, no, give it, or you, let's say you give it in custody of someone, hey, please, if someone claims the goods, return it back to him. He is not the owner. So tomorrow if no one claims those goods, can you go and claim those goods from that person to whom you have handed over the goods? Yes. He says, no, I will not give. Can he do that? Let us say you are in a restaurant, you find a wallet. You give it to the manager that please return it if someone claims. After a week you go and ask, did anyone claim that wallet? He says no. You say return it then to me. No. Now it is with me, I am the owner. Can he do that? No. No. The finder gets the position of the owner of the goods. He has the rights over the goods as if he is the owner against the whole world. But tomorrow if the owner comes and tells him, give me my goods, can he say, no, I am the owner now? No. Against the whole world, he is the owner except the owner of the goods. If owner claims, he has to return, but no one else can claim the goods from the finder. I hope it is clear to everyone. The last one, termination of bailment. If the goods are destroyed, the goods for which the bailment was made, the goods are destroyed, right? Something happens to the puppy. I don't want to give an example also. The time for which the bailment was made, that is over. The purpose for which the bailment was made, that is over. If it is a gratuitous bailment, it can be terminated anytime. You remember? So you have your exams and you lend your book from your friend, and he says, okay, return it after the exams are over. Obviously, he is not charge you. The day before the exam, he comes and says, give me my book back. You have to give. And death of the bailer or the bailee. Obviously, the bailment will terminate. I hope bailment is clear to everyone. Can we move on to the next one? Contract of pledge. Yes. Now, the next special type of contract, pledge. If you remember, in fact, when I was talking about guarantee, I had talked about pledge. When I give a human as a security, right, for the payment of a loan or performance of the contract, I call it as a guarantee. But when I give things as a security, either for the payment of a loan or for the performance of the contract, we call it as a pledge. A pledge is a bailment of goods. So contract of pledge is also a contract of bailment. Is a bailment of goods as a security for the payment of the debt or the performance of the contract. Now please understand, the person who gives the goods is the pawner, that is the bailer, and the person to whom the goods are given is the pawnee or the bailee. So let's say P1 gives his gold chain to P2 for a loan. So P1 is the pawner or the pledger, or the bailer, and P2 is the pawnee or the pledgee or the bailee. So here the rights of the pawner is the same as the rights of the bailer. The duties of the pawner is the same as the duties of the bailer, and the rights of the pawnee is the same as the rights of the bailee, and the duties of the pawnee is the same as the duties of the bailee. Okay. Now apart from that there is two more rights of the pawnee here, right, which was not given in bailment, but apart from that there are two more rights of the pawnee here. First of all, he has a right of lien. Ma'am, right of lien was also there. Yeah, right of lien was also there, but here it's a little different. If you remember that tailor wala case, the tailor, if you don't give him the, what do you say, the payment for the, what do you say, for the shirt that he has stitched, can he exercise a lien over the shirt? Yes. Now you go and he was supposed to deliver the shirt to you today, but after 2 months you go and claim the shirt. He says, I kept for 2 months this shirt, so it was occupying my space, my shelf, pay me for that. Right? I repeat again, he was supposed to deliver the shirt to you today, but you went after 2 months to get that shirt. He says the shirt was kept in my shelf, it was occupying the space. It was occupying that space, pay me for that. Right? He says it was occupying the space, pay me for that. Tell me. You say, obviously you will not, you say, why should I pay? No, I did not come, I couldn't come, whatever. He says, okay, lien, I won't give you the shirt, go. Can he exercise a lien for that? No. He can exercise a lien for the charges, but he cannot exercise a lien for the expenses. But when it comes to pledge, the lien can be exercised for principal amount, for the interest amount, as well as for the expenses. When it comes to pledge, lien can be exercised for the principal amount, interest amount, and for the expenses. Let us say I took a gold chain from you or a diamond necklace from you as a security. Now I did not want to keep this diamond necklace at my house, too risky. If someone steals, my money is also gone, the necklace is also gone. So I took a bank locker and I kept it in the bank locker. So whatever is the charges for that bank locker, if I don't get that, I have a right to exercise a lien over the goods. Right? So I repeat again, the pawnee can exercise a lien not just for the principal amount and interest amount, but also for the ordinary expenses. Now the pawnee shall also have a right to sell. If I do not receive my money, I am going to sit and cry, my money not received, what do I? No, I am not going to do that. The goods you have given me, I am going to sell off those goods and recover my money. So I have a right to sell. Now it is not necessary that the sale proceeds and the amount will always be, the sale proceeds and the amount that I am supposed to recover from you will always be same. So let us say if the sale proceeds is more, let us say you have to pay me 1000 rupees and on selling the goods I got 1200. If you remember, I just explained it in bailment also. I can only keep 1000. The 200 I have to give it to you. On the other hand, I have to receive 1000. The sale price was only 800. So this 800 so I will retain. I will also sue you for the 200. So if the sale proceeds is more, the pawnee should refund the excess. If the sale proceeds is less, the pawnee can recover the deficit from the pawner. I hope it is clear to everyone. That is it, because as I said, the duties are the same, so we don't have to go into that part at all. Right? We don't have to go into that part at all. Now, pledge by non-owners. Can a non-owner of the goods pledge the goods? You know, this always reminds me of Nemo Dat Quod Non-Habet, Sale of Goods Act, if you remember, Nemo Dat Quod Non-Habet. It always reminds me of that. So, sale by a non-owner, pledge by a non-owner. If you will actually, when I go through these points, you will recall all the points are the same as that of Nemo Dat Quod Non-Habet. So, should we move on? Yes, should we move on? Yes. So, the first one is sale by, wow, oh my god, okay. The first one is sale by a mercantile agent. So, who is a mercantile agent? He is a middleman, And in fact, you know what, one of the rights of a mercantile agent is he can pledge the goods. So when a mercantile agent, obviously few conditions have to be fulfilled. He is acting in the ordinary course of the business. That is, he is not a mercantile agent for this single contract, but he does the work of a mercantile agent, has the possession of the goods with the consent of the owner, or has the document of title to the goods with the consent of the owner, and sells it to a bona fide, pledges it to a bona fide person. That is, the pawnee is not aware that he is just that he is not a genuine person. The pledge is absolutely valid. So where a mercantile agent has the possession of the goods, is acting in, and the pawnee is acting in good faith, the pledge is valid. Pledge by a seller or buyer in possession after sale. So I have sold the goods to you, or I have given the possession of the goods to you, but I have not sold the goods to you, right? So first let us say S sold his goods to B, but the goods are still with S, and S goes and pledges the goods to P. This pledge is absolutely valid. But ma'am, he is not the owner, that is why it is pledged by a non-owner, right? That is why it's a pledge by a non-owner. So where S has sold the goods to B, but the goods are still with S, and he goes and pledges the goods to P, the sale is the pledge is absolutely valid. Where S has given the goods to B, not sold, let us say sale on approval, right? Sale on approval, and B goes and pledges the goods to P, the pledge is absolutely valid. So if the seller, after selling the goods, still has the possession of them, or the buyer obtains the possession of the goods with the consent of the seller before sale, and pawnee acts in good faith, you know what, in all of the cases the pawnee has to act in good faith, then the pledge is valid. Pledge by a co-owner. So let us say M, N and O have jointly purchased the property, and N and O, they ask M to keep the goods. Let's say M, N and O have jointly purchased the car. A property cannot be immovable because pledge is always for movable goods. So let us say M, N and O have jointly purchased the car, and N and O, they don't know how to drive. So they say M that you please keep the car with you. Once we learn how to drive, we will also use it. Now M goes and pledges of this car to P. The pledge is absolutely valid. So if any one of the co-owners has the possession with the consent of the other co-owners, and the pawnee acts in good faith, the pledge is valid. One thing you will see, in all of the cases the pawnee has to act in good faith, that is, the intention is not to deceive. And the last one, a person who is in possession under a voidable contract. So if I have the possession of the goods under a voidable contract, and before the contract is cancelled, very important, because in possession under a voidable contract, before the contract is cancelled, I pledge the goods, the sale is valid. S sold his goods to B, and B pays by check which B knows would bounce. So can I say B has committed a fraud? S sells his goods to B, and B makes the payment by a check which B knows would bounce. So can I say B has committed a fraud? Yes. So contract is voidable at S's option. Now before S cancels the contract, this part is important because it is in possession under a voidable contract. Please understand, this is a revision class, I cannot go slow. Before S cancels the contract, B pledges the goods to P. The pledge is absolutely valid. I hope it's clear to everyone. Can we move to the last one, contract of agency? Yes. So moving on to the last one, contract of agency. So what is a contract of agency? Agent is basically representing a person. So when someone does the work for me, he is my agent, right? When someone does the work on my behalf, he is my agent. So what is a contract of agency? Agent is a person appointed to do any act for another or to represent another person, right? So basically, let us say you have some case going on for the income tax, and you say that it is better my auditor goes on my behalf because he will be able to answer better. So you ask him to go and represent. So he is your agent. So agent is basically a person who is doing the work for another, or he is representing another person. Now, what are the essentials of agency? Obviously, there has to be an agreement. You cannot just random say, okay, I am an agent for this person without that person actually telling you. So there has to be an agent who does the work. Come on, if you tell me to do the work also, I will not do. So without telling, who will do the work? So for an agency, agreement is mandatory. There has to be an agreement where the principal says to the agent that you are supposed to act on my behalf. Then consideration may or may not be present. In agency, consideration may or may not be present. If you remember the case where I told you, you act as an agent for your mom and the balance goes in your pocket, you are getting consideration. On the other hand, you act as an agent for your dad, and dad though, oh my god, even 1 rupee change I will give back to him. I cannot keep anything in my pocket, so I am not getting anything. Still I am acting as an agent for him. And for personal contracts, agents cannot be appointed. You have to go to the IT department, you ask your auditor to represent you. Okay, you are supposed to get married. Can you say, hey my friend, go and represent me in the marriage and get married on my behalf? Like seriously, can you do that? So when the contract is of personal nature, agents cannot be appointed for that, right? There are two types of agency. This is basically implied agency is a huge one, and you can get questions from that quite a lot. Express simply, I tell you, please be my agent. That's it. Implied is, I am not telling you to be my agent, but the situations or conduct or the relationship of the parties suggests the existence of an agency. I am not asking you to be my agent, but the situation or our relation or the conduct suggests that you are my agent. So agency can be by holding out, by necessity, wife as an agent, by ratification, and by operation of law. What is this by estoppel? You already know the meaning of the word estoppel. This is one word which is used in law so many times. I am not your agent, but by my words or by my actions or by your words or by your actions, you make everyone believe I am your agent, or I make everyone believe I am your agent. Right? You say, meet her, she is my agent, and I keep quiet. Obviously, I am an agent. I say, I am his agent, and you keep quiet. Then what? I am your agent. So, where a person by his acts or words make others believe he is the agent of another, and such person does not deny it, or where a person lets another believe that another person is his agent. Now, if I go and make a contract in your name, are you liable? Obviously, because you did not deny or I did not deny. So if I make a contract in your name, you are liable. The next one, agency by holding out. This is generally, you know what, people think estoppel and holding out is the same, but it is a little different. In estoppel, there is no agency relation at all. Whereas in holding out, there was an agency relationship earlier. Earlier, I was your agent, but now it is terminated. So when it is terminated, public notice should be given. No, otherwise everyone will think I am still your agent. So if public notice is not given, people are still under the impression that I am your agent. And because people are still under the impression that I am your agent, if I make a contract in your name, they will believe it is on your behalf. This is holding out. So please understand, generally what people think is holding out and estoppel is the same thing, but it's not the same. Estoppel, there was no relationship of agency and agent and principal. Whereas here, earlier I was your agent. But now this relation has been terminated. So when this relation is terminated, public notice should have been given. We did not give any public notice, so I continue to be your agent. And if I make any contract in your name, you are liable. So a person was the agent of another but is no more the agent, and public notice was not given. By necessity, in an emergency situation, when one person acts on your behalf, he was unable to communicate you and he acts on your behalf. This is what? Agency by necessity. You order some goods, midway the goods are perished, you are not in India, they try to call you, your phone is not reachable, you did not want to pay, extra money to get it international, roaming, and you did not want to pay for that. So your phone was switched off, you were on a vacation, now this person is trying to contact you, unable to contact. So just to save your goods, he sells off the goods. This is agency by necessity. So, but here there are conditions. There must be a real necessity. There should be some reason to sell the goods. Okay, I don't have petrol or fuel in my car, so I sell the goods to pay for that. That's not a necessity. So there must be a real necessity. He was not in a position to communicate and he acts as a man of ordinary prudence. What is this ordinary prudence? The goods are sold 200 rupees per kg. You sell it off for 40 rupees per kg. This is not ordinary prudence. You are doing wrong here, right? So the agent must have acted as a normal human being would have acted. Then in that case, he becomes an agent by necessity. Then by ratification. Now, this you need to be very careful about this ratification. Ratification means accepting an act which was done without your authority, right? What is ratification? Ratification means accepting an act which was done without your authority. Accepting an act which was done without your authority. Now, in this ratification, listen very carefully, there are two cases. I am not your agent. This is not estoppel. I am not your agent and I go and contract in your name. Now this person comes to you to hold you liable and you pay him for that. By ratification, you have accepted me as your agent. I am not your agent. I am not your agent. I go and buy this land in your name from this person. He comes and says to you, please pay me the money. You pay the money for the land. I become your agent by ratification. Where I have done an act without your authority, not being an agent, but later you accept it. Later you accept it. So I have become an agent by ratification, or I am your agent and you have given me some authority to do the work. Ajay, tell me, if you don't pay for that land, will I become your agent? No, I am not your agent. But when you pay for that land, you have accepted it, I become an agent by ratification. On the other hand, I am your agent. I am your agent. You have given me an authority that please do this work. I do an act which is more than my authority. Right? I repeat again, I am your agent and you give me some authority to do the work. I go and do the work more than my authority. Right? Now, I am your agent and I am acting outside my authority. You can do two things. You can say, why should I be liable for what you have done? I did not tell you to do. I am not responsible. So when you do that, you have not accepted my work and you will not be liable for the work that I have done over the authority. On the other hand, when you say it's okay, no problem, chalo, I accept it. I have not done the act within my authority. I have done the act outside my authority, but you have accepted it, you have ratified it. So ratification has two cases. First is I am not even your agent and you accept my act. Second is I am your agent and I act outside my authority and you accept it. Then you are liable. However, there are some conditions here. If the act must be done as an agent and contract for an identifiable principal. That means I should say that I am acting as an agent for this person. Principal must have contractual capacity. That means to hold the principal liable, the principal must have contractual capacity. That means he must be a major sound mind, all right. Ratification is to be done with the knowledge of the material facts. So before you accept it, you should be aware of all the material facts. Okay, any land, no, you should be aware which land, what price, all of that. Ratification can be done only for the whole contract. You tell me, I am your agent, you tell me get me a loan of 1 lakh. I get you a loan of 5 lakh. You can reject. I am only liable for 1 lakh. So 4 lakh I will be liable. You say, okay, I will be liable for this 1 lakh plus 2 lakh. The rest 2 lakh you are liable. No. You can either accept the whole 4 lakh or you can reject the whole 4 lakh, but you cannot do it in part. So ratification must be of the whole contract. Ratification must be communicated within a reasonable time. Only lawful acts can be ratified. I am your agent, you tell me go and collect the rent. I go, I take some goons with me, I hit them and then I come and say, oh yo sir, save me, I did all these things. Can you do that? No. You cannot save me. Ratification can only be for lawful acts. Principal must be in existence at the time of contract. So basically pre-incorporation contracts for a company which is not yet incorporated. Pre-incorporation contract can never be ratified. A new contract can be made cancelling the old contract, but it can never be ratified. And the last one, by operation of law, we have wife as an agent. We will go to it next. Operation of law, by the effect of law. For example, partners. One partner is the agent of the other partner by the operation of law. Wife is an agent and she can use the credit of her husband. She can pledge the credit of her husband. That is, she can take goods on credit in the name of her husband. However, the husband is not liable if he has expressly forbidden his wife to pledge his credit. That if he has specifically told his wife that you cannot buy anything in my name, not liable. The goods are purchased are not necessary. So the liability of a husband is only for necessaries. So if she goes to the jewelry store, okay, give me 1 crore necklace, not responsible. But please understand here one thing. Here there is no flat slab for necessaries. For one female, maybe 1 sari is a necessary. For another female, maybe 10 saris is a necessaries. Right? For one female, jewelry is not even a necessary, whereas for the other, to maintain her status, jewelry is a necessary. So that depends on the status of the person. So here there is no flat slab to explain necessaries. That depends on the status of the person. However, he is only liable for the necessaries. If he has given sufficient funds to the wife for purchasing the articles, then he is not liable. He is not liable. The articles needed to the knowledge of the tradesman and has expressly been told not to give credit. Or if the husband has gone to the shop or the business, whatever, and told them very clearly, if my wife comes to purchase anything in my name, do not sell it to her, I am not responsible. Then if you sell, you are only responsible. If the husband and wife live together, wife is the agent of the husband and she can use the credit of the husband. If they are living separately, and they are living separately not because of the fault of the wife, then she is the agent, right? On the other hand, if they are living separately not because of the fault of the wife, but the husband is giving her maintenance expenses, then she is not the agent because you are already getting expenses. If they are living separately because of the fault of wife, she can never be the agent of the husband. I hope it's clear to everyone. Yes. Can we move to the next part, sub-agent and substituted agent? Yes. Now, what is a sub-agent? When the agent appoints another person as an agent, he is the sub-agent. Whereas substituted agent is, the basic difference is, when I say sub-agent is not the agent of the principal. He is the agent of the agent. Whereas substituted agent is the agent of the principal. He is directly under the control of the principal. Sub-agent is employed by an agent and acting under the control of the agent, whereas the substituted agent is named as an agent under the express or implied authority of the principal and acts for the principal. So let us say I have you as an agent and I tell you that for this particular job, let us hire some other person to do the work. So he is not appointed under your control, he is appointed under my control. He is a substituted agent. For the substituted agent, I am only responsible, I am only liable. But for the sub-agent, you are liable, not me. You cannot appoint a sub-agent because I have delegated the work to you. How can you delegate it further? However, if it is done with my authority, then you can appoint and I am liable. A sub-agent cannot be appointed, and if appointed, principal is not liable. However, if the sub-agent is appointed with the consent of the principal, then the principal shall be liable. To the principal, the agent shall be liable for the sub-agent's act. However, if the sub-agent does anything, you are responsible to me. Right? Named principal, unnamed principal, undisclosed principal. Named principal, I am acting as an agent. I am acting as an agent for Mr. A. Obviously, who is liable? Principal is liable. Unnamed principal, I am acting as an agent. For whom? Oh, that I cannot tell. But for whom? That I cannot tell. Who is liable? If I disclose the name of the principal, principal is liable. If I don't disclose the name of the principal, I am liable. Undisclosed principal, I am acting. I am not even saying I am acting as an agent. I am acting. Who is liable? I am liable. Now, so here only you have seen personal liability. So there are some cases where the principal, generally what happens, for the acts of the agent, the principal is liable because I am just acting for the other person. So for the acts of the principal, the agent is liable. I am so sorry. For the acts of the agent, the principal is liable. However, there are some cases where it is the agent himself who is liable. For example, if I am acting as an agent for you, even though you are not my principal and you don't ratify it, I am liable. Or if I am an agent and I am acting outside my authority and you don't ratify it, who is liable? I am liable, right? If I have not given the name of my principal, or I don't say that I am acting as an agent, who is liable? I am liable. So a agent is personally liable in case of undisclosed principal. In case of unnamed principal and the agent refuses to tell the name, sub-agent is improperly appointed. What is improperly appointed? Without the authority of the principal. Pretended agent, if the principal does not ratify. When I am not your agent and I act as an agent for you, I am a pretended agent and you are the pretended principal. If the principal is a minor, or if the principal stays outside India, agent acts outside the scope of his authority and you don't ratify it. Principal resides in a foreign country, when the principal cannot be sued in the court of law. For example, these president, prime minister, they cannot be sued. To file a case against them, you need a permission of the court. So when I am acting as an agent for these persons, I am liable personally. Where contract specifically provides that the agent is liable, misrepresentation or fraud by the agency coupled with interest, which we will do in a while, civil or criminal wrong committed by the agent. I murder someone, can I come and say you are liable? No, I am liable, I have done that. Termination of the contract of agency, if there is an agreement between the parties, it will be terminated. Revocation by the principal giving notice to the agent or vice versa. I give a notice to you, I don't want to be your agent, you give a notice to me, you are no longer my principal. Expiry of time, death or insanity, insolvency of the principal, destruction of subject matter, principal becoming an alien enemy. I really don't need to explain also all these things. Dissolution of company where the agent or principal, if the agent or the principal is a company, if the company is dissolved, if a human is there, I say death of the human. But if a company is an agent or a principal, so the death of the company which is winding up. So if the company itself is wound up, how can be I an agent or principal anymore? Or performance of the contract. However, if the agent has performed or is in the course of performing, I ask someone to deliver me some apples from Kashmir. Then later I call him and say, please don't deliver, fine. He has already started his journey and he has already reached almost the halfway. I call him, please don't deliver. Can I do that? No. He has already started performing. I am liable for this contract now. Or if the agency is coupled with interest. What is agency coupled with interest? There was an interest of the agent and because of this interest, agency was made. There was an interest of the agent or the principal and because of this agent rather I should say, and because of this interest, the agency was made. I have taken a loan from you. Now you are asking me to repay. Finally I tell you, okay fine, do one thing, I have a property, you sell that property. You sell on my behalf this property. Once the property is sold, you take your commission, you take your loan amount and then give me the remaining amount. Here the purpose of the agency was to pay off that debt. Yes or no? Here the purpose I appointed you as my agent was to pay off that debt. This is agency coupled with interest. Here the purpose of my loan, my contracting you to sell that land was to pay off the debt. So this is agency coupled with interest. Please, one thing to be understood is the interest should exist before the contract was made. If let us say I tell you please sell my land and then I take a loan from you, that is not agency coupled with interest. Agency coupled with interest is there was an interest and to fulfill this interest the contract was made. Right? So the principal had some interest or the agent had some interest in the contract and for that the contract of agency was made. Now this, unless the land is sold, the agency cannot be terminated. Unless the land is sold, the agency cannot be terminated. With this we are done with this chapter. I hope this discussion has helped you, and if it did, leave a like and a comment so that we also get motivated that at least it is helping you all, and all the best for your exams. Thank you so much, all the best and stay motivated.